But we have a lot of stuff to cover tonight, so I'm gonna hand this over to JD, and then we're gonna cover whatever you guys want to cover about local stuff and county stuff and anything else JD wants to mention. And then we're gonna talk about transitioning into some more activism. Because there's the campaigns, but there's a lot of work. And I didn't get to tell you all the cool stuff that this group is gonna be able to do pretty soon. And I need your help on it. In fact, we need your help on Thursday. So JD, let me hand this over to you, and we will go until 7:15 or so. Questions and everything, is that all right?
Okay, sure.
Okay. JD Lambright, folks.
All right.
Here we go. Well, thank you very much, and I appreciate the opportunity. When Dee invited me, was it Sunday night or whenever it was? And so the only thing I felt bad about, I think I spoke to the group back in May. Let me ask you a question. How many of you have not heard me speak before? Okay, yeah, my family. Reason I ask that because some of the slides here are ones I've used before, and I'll just try to skip over those and touch on some new things. Now, one thing I did see on the agenda, it said outside my name, it has the Joe Corley Detention Center. I don't think I have a single slide about Joe Corley, but whatever questions I can answer, it's a federal detention center in Conroe that the county used to own. They sold it about a year and a quarter ago. But I'm going to take some questions and see if I can do my best to answer. Because of the feedback here. I'm trying to stay out in front of the screen also. As Julie says, being the attorney, the chief legal advisor for the county, there's some things, no matter how much I might like to talk about, we just can't talk about everything with attorney-client privilege and if there's negotiations and things going on. But I'll do my best, anything we can to try to touch on that. Just quickly, most of you are familiar with this. This is what my staff looks like. I have a staff of about 30, about 15 lawyers, and then the rest are legal assistants, a victim coordinator that works with all of our juvenile victims, as well as I have 2 investigators, or they're cops. They're masterpiece officers, just like any other cop, have a full power any cop. I do want to tout this. People may have already heard this. My first year in office that we completed, the county attorney's office was named the Department of the Year. And I'll just tell you, the credit goes not to me, the credit goes to my staff. We've got an incredible group of people. Judges, attorneys, everybody tells me all the time, how did you get these people to give up their private practices and come to work in the county attorney's office? And I don't know how, but we did. And this is the first time in the history of that award. The award is chosen by county employees. And this is the first time in the history of it the county attorney's office has ever won that. So very appreciative of that on behalf of my staff here. The county has about 2,300 employees, and so here's who we advise. I just kind of list here all the elected officials. I'm not going to name every one of those, but it gives you an idea of the elected officials we have in the county. We're the legal advisor for every one of those, and we're usually involved on a daily basis trying to answer questions for them, give them legal advice. Sometimes we're telling them how you can do something legally or why you can't do something legally. And I told them from day one what I'd like to do is keep you guys off the front page of the newspaper unless it's good news. And that's a job sometimes. We also, for all the department heads, again, I'm not going to name all the department heads. That gives you an idea of department heads we also represent. So there's a lot at stake depending on us, which is why we have such a diverse group to be able to advise and consult with all these people here. Some of the things we do, we handle all the civil litigation for the county, both in civil court, in both federal court and state court. The county gets sued regularly. In fact, I gave a talk last Thursday, I think it was, and I told them the county gets sued quite often. I got back that afternoon and I've been served with papers that our sheriff had been sued again and the county had been sued. There's kind of no end to that. Sometimes we are initiating suit, but more often we're defending the suit. Maybe a county dump truck rear-ends somebody on a road. Obviously, if we're liable, we just have to work out a settlement and take care of that. But it's anything, most of the lawsuits, probably 80% of them involve the law enforcement. People sue our deputies, our sheriff, our constables, you name it. claiming their civil rights were violated when they were arrested and detained and so forth. And that's what the most recent suit was about that. We handle all the juvenile cases for the county. We have about 1,100 juvenile cases a year. We handle any juvenile case, and those are kids between the ages of 10 and 16. And whether it's a Class B misdemeanor, which is the lowest class we handle, like possession of a small amount of marijuana, for example, up to and including capital murder. And since I've been in office, we've had one juvenile capital murder, a 13-year-old, along with a 19-year-old committed a capital murder. We prosecute the 13-year-old. Brett Ligon, the DA's office, prosecutes the 19-year-old. You can imagine how many contracts the county gets involved in. We have a lot of employee issues we deal with 2,300 employees. There's always somebody filing grievances, and I think we're going to see more of this because, as y'all all well know, we've got a number of new elected officials coming in. Obviously, there's going to be some changes of personnel associated with that. Some people don't like that, and they're going to file suits and file grievances. So at any given time, we probably have 8 or 10 of those kind of cases going on. Just some of the legal matters we handle. Again, I'm not going to go through all of those. Everybody, I'll touch on one CPS case. We're the attorneys for Child Protective Services. I have a 6-person team on that, 3 lawyers and 3 legal support staff. We have about 400 CPS cases at any given time. Open records requests. That's one thing I said during the campaign, because a constant thing from the media and others was the county would not release information that people think they're entitled to get. And I'm all for free and open, transparent government. And we handled about 800 of those in 2013. The county got about 12,000 open records requests in 2013. But we only see those when that entity that served with it, Sheriff's Department, gets most of them. They got about 8,000 in 2013. If that entity feels they cannot or will not turn that over, they give it to us, we issue an opinion, and then it kind of goes from there. But we have really, really streamlined the public information request situation. The Sheriff's Department is very happy with us there. And so I think we'll see this number down of the ones we have to handle. If people are entitled to the information, we give it to them. It's really straightforward. If you're not entitled to it, maybe there's an ongoing criminal investigation, you can get some basic information. And what we've discovered, most of the time, that's what people want. Maybe they're involved in a car crash and they just need to get some records from the county, where previously the county attorney's office would tend to fight all those and send everyone to the attorney general's office. So we really have to streamline that. Huge increase in protective orders over the last year. When I came in, we were averaging about 10 a month. Now we're averaging about 25 a month, more than 1 a day. These are predominantly women. It doesn't have to be, but most of the time it's women seeking help and protection against an abusive spouse or boyfriend. It's got to be some family member. And in fact, 2 judges have come to me in the last 2 weeks really thanking us for that for 2 reasons. Just talking about how well prepared my staff is. I've got 3 different attorneys that go appear in court along with a person seeking the protective order. They are very prepared when they get there. They know their stuff. And an important part of it, they screen them in advance. It doesn't help anybody to waste judges' time, because so many people come in wanting a protective order, but once you do some screening, they want a protective order because I'm in the middle of a divorce and I want to get the leg up on my husband or leg up on my wife. You don't qualify in any way for a protective order. There's not some direct threat, of abuse or harm. So we're really screening those, and like I say, just unsolicited 2 judges contacted us just the last 2 weeks on that. We also handle all the worthless checks for the county. We don't prosecute those. The DA still handles the prosecution, but we handle the collection of those. And since I took office, we have collected $474,000. That's for merchants, mom and pop stores, just some individual. You get a hot check, and we aggressively pursue those. And you see, by now we're probably $500,000. This was updated the last couple of weeks. Big deal was made during the campaign about the sheriff. The sheriff needed a full-time attorney, and we challenged that. I actually wasn't even quite in office yet, and I said, we're your attorney, we'll take care of your legal matters. And these are the kind of things the sheriff wants help on. And I quickly determined, having been a lawyer for 13 years before taking office and handling all kinds of civil, family, criminal matters, there is no one lawyer that can cover every one of these areas. I mean, you're just gonna have a jack of all trades and be a master of absolutely nothing. And so what I've done for the sheriff, we have 3 different lawyers that advise the sheriff's department on these things. And every Tuesday morning, I have a lawyer at the sheriff's department, spends about a half a day learning all their issues, questions, and so forth, comes back, and then we figure out who's gonna handle it. And, thank you. It made no sense to have somebody separate in the county attorney's office sitting at the sheriff's department when we're the ones that are the legal advisor for the county. The sheriff, the chief, everybody are greatly pleased with that. It's working very well all the way around. So I wanted to mention this one, this illegal alien resolutions. This is a topic that's kind of a hot topic lately, been in the newspaper. Most of you may be familiar with the facility out on League Line Road where they're housing young, if you will, illegals. And we get questions a lot, well, why can't the county, why won't the county do something about that? A couple of reasons. One, that facility is in the city limits, so we couldn't do anything anyway. But even more importantly than that, the county has no authority whatsoever other than what the legislature gives it. Like a city or a municipality has far more authority than the county does. Essentially, a city can enact any ordinance they want to unless there's something the legislature has passed that says you can't do that. County is just the opposite. We can only do what the legislature has said you can do. So we're greatly limited. People have come to us one, well, we'd like an ordinance controlling taxi cabs. We have registered sex offenders operating taxi cabs in the Woodlands. Certainly we'd like to do something, but we got no authority to do that. So the solution is you go to the legislature and try to get a law change there. Just today we issued a memo to all of our commissioners on this topic here. And so there's one reason we can't do it, for the reasons I just described. Another reason that a lot of people may not be aware of, and most of this, well, all of this is associated with the Joe Corley Detention Center, which is a federal detention center right here in Conroe, adjacent to Montgomery County Jail. And it's a 1,287 bed facility, and it houses strictly federal inmates there. But since 2008, when that facility was opened, the county has contracts with ICE, which used to be called INS, Immigration and Naturalization Service. It's now called Immigration and Customs Enforcement the last few years. So the county has contracts with ICE, and we get paid for that. The county also has contracts with the U.S. Marshal Service. And those are the 2 entities that have inmates in Joe Corley. And then Joe Corley is now owned, managed, and run by a company out of Florida who's a big player in that kind of business named GEO. And so we also have contracts with that. The county is paid, and all we really do is kind of manage that contract with the feds, with the ICE, and with the U.S. Marshals, because the feds want to deal with another government entity. So they want the contracts between the feds, between the county, and just for a little bit, very little bit, administering that contract, the county gets $500,000 a year. And GEO sends us $41,000 and some change every single month for doing that. I think it's been advertised. Galveston County has passed a resolution, and we reviewed that. The city of Lamarck has passed a resolution regarding illegals. And the most recent one, there may be others, the most recent one I'm aware of is city of Magnolia. These are really feel-good kind of things. It says, you know, we're not going to allow illegals to do this, we're not going to have any housing for them. They're not worth the paper they're written on. They're totally unenforceable. But the additional part of it is our county, and has had since 2008, these contracts in place saying that we are going to agree to assist and support, providing the inmate facilities at Joe Corley. So we'll probably touch on some more of that during the Q&A. Also, as a lot of you may know, GEO has plans to build another facility like Joe Corley immediately next to it. GEO already has the land, they have had for some time, to build another facility, a sister facility to the Joe Corley Detention Center. And part of the purchase and sale agreement for Joe Corley was the county would, I remember the exact words, not oppose that, would do anything to help promote that, not stand in the way of them getting additional contracts with the feds. So that's an issue the county has It's different than all these other municipalities and other counties that are choosing to draft such ordinances. Let me just quickly, I just want to touch on 4 or 5 cases here that make the news a lot lately, to kind of let you know the kind of rest of the story. One of them, anybody hear in the paper about this 5-month-old baby that was ejected out a car window in a car crash? We handled that case from a CPS standpoint. There's the father of the child there. He's currently in Montgomery County Jail. Now, I don't deal with him per se. Brett Ligon will be prosecuting him. But what was happening, he and his wife got into an argument at a grocery store. And he storms out in their vehicle, has the baby, 5-month-old baby, in a car seat. He crashes over a mailbox, flips the car over and everything, and somehow the baby in the car seat goes flying out the car window. And the injuries were very minor. I mean, it was a miracle how that happened. I'm less concerned about it, but also amazing, I guess, the father's injuries were very minor. In fact, they were so minor, instead of reaching down and picking up the baby, he runs off and leaves the baby lying out in the road. And so that's why we got involved, and through CPS we took custody of that little baby. And he's in our jail with, like I say, a $200,000 bond. We just had a hearing week before last because mom wants the baby back. And on the face of it, you know, oh my gosh, mom wasn't in the car. She wasn't driving the car. She had nothing to do with it. In fact, mom said, there was no argument. I don't know what y'all are talking about. Well, we got the video from the grocery store. You know, we're usually a step ahead of these people. And the video shows this big, it wasn't a physical, it was a very verbal argument that ensued. So she's lying to us from day one. But she is fighting to get the kid back. 2 weeks ago, the judge ruled in our favor. She's now appealing that to the Beaumont Court of Appeals, so it will go on. What most people don't know, this couple have a prior CPS history. In fact, just last year, we terminated their parental rights on another child. And even the mother in this case didn't say this, but another mother, young mother in another case, just flat, she testified on the witness stand here a few months ago, because she just had her 5th child. And CPS gets involved every time. She has no business having children. Her comment on the stand was, you keep taking them, I'm going to keep making them. That's the mentality we deal with on some of these. And so we'll see what Beaumont does if they decide to return that. But on the face of it, you think, well, mom didn't do anything. Why don't you give the kid back to her? Well, you need to know, the rest of the story. I had mentioned this case, I think, previously, the Jenny Roberts case. Jenny Roberts was a lady in Houston. We have been fighting this case vigorously for about 18 months, right when I came in office. Ms. Roberts was at a bar one night in the Woodlands. Her husband was out of town on a trip, and she was highly, highly intoxicated, and typically gets involved in affairs and everything else while hubby's out of town. So she's asked to leave and gets in an altercation, and so there's off-duty sheriff's deputies there, and she ends up getting arrested, taken into custody. Well, now she claims she's permanently brain damaged and these cops did it to her. And we investigated this case like crazy, knew that was not the case. And of course, to defend any case, we have to go to Commissioner's Court in executive session. That's the only time we can meet with our clients together, to avoid open meetings violations. So we appraise them of it, and they have to give us permission to defend the case. Since I've been there, they've never declined to give us permission to defend it. But she wanted millions of dollars in damages, and claiming brain damage and everything. And you can't believe what we turned up in our investigation. She may be brain damaged because her husband beats her up regularly, but these cops didn't do anything. We fought it for a year and a half. See, it was set to go to trial May the 8th of this year. 1 week before, April 30th, she dropped her case. But the reputation a lot of times of government, sue them for $1 million, they'll cut you a check for $100,000, And a lot of attorneys like to take those things on a contingency basis. Attorney gets maybe 40%. Well, we're trying to change that reputation. And so a week before trial, she realized, this is not going well. She dismissed the case, and we paid her absolutely nothing. On the juvenile prosecution side, a lot of people don't realize the juvenile cases we have. That's what it looked like in 2013. And In particular, notice 53 sexual assaults. That's the highest thing other than, drug offenses, which you probably would expect. I don't have the latest number since April 30th, but we may surpass that by 12% or so before the year is out. But the sexual assault cases are particularly disturbing to us. And keep in mind, we only prosecute juvenile cases. So that means a juvenile is perpetrating on another juvenile. I've never had a case where juveniles perpetrating on an adult. I guess it could happen. But a couple of these cases we have just tried in the last 2 or 3 weeks. I just wanted to touch on here. I had told y'all about this case before. You may wonder, wait a minute, he's a juvenile. How can I show his face and his name? The difference is his case was so egregious. He was 16, Llewellyn Van Sligtenhorst. His victim was his 6-year-old relative that he was a babysitter for in the grandmother's house. And we first got notified by Homeland Security about the case and issued a search warrant. They found over 4,000 images on his computer of child porn, a lot of videos and so forth. And given his age, he was 16, and given the extremely egregious nature of this, we sought to certify him as a stand trial as an adult. You want to do big boy things? We're going to take you to big boy court. And a lot of y'all hear Judge Hamilton, 2 weeks ago, I guess? At that time, Judge Hamilton was the juvenile court. She agreed with us, certified him to stand trial as an adult. So that means we handed it over to Brett Ligon, the DA, who a lot of y'all probably know. We were so familiar with the case, Brett asked us to also stay on and assist. But I just want to give you the rest of the story. This is the kind of things, we charged him as a juvenile with 46 felony counts. And what he was just doing unimaginable things, like unlawful restraint. That's like using tape and taping him down and performing just the most egregious sex acts and stuff. It's just sickening cases we deal with. So in October of last year, we got him certified to stand trial as an adult. And here's what just happened. July the 8th, and Judge Mychalk, who you heard from last week, he was in Judge Mychalk's court. And I think he realized the handwriting was on the wall because he's facing, he could not get the death penalty because of his age, but he was facing up to 5 to 99 or life. He pled guilty and agreed to a 50-year sentence. And he's not eligible for parole until he serves 25 of that. So, and one nice thing too, you hear about plea agreements and plea bargains all the time. Part of each and every plea agreement is they waive their ability to appeal. So if he'd gone to a judge or a jury and got, let's say, a 50-year sentence, he could appeal that. He cannot appeal this. So he's off the streets for a long, long time. And thank goodness for Judge Hamilton and seeing this kid. So, juvenile prosecution is a lot about rehabilitation. You got young people that do some incredibly stupid things. That's not what this case was about at all. This case we just finished last week or 2 weeks ago. I just wanted to mention this one. Again, the perpetrator was a 14-year-old boy. And the reason I mention these things, these are not cases where you've got a 14-year-old boy having sex with his 13-year-old girlfriend. I'm not saying that's right either, but that's a totally different kind of case than the ones we really pursue aggressively here. His victim was a neighbor of his that lived upstairs from him, 4-year-old girl. 2 first-degree felonies he's facing. And his attorney elected for a jury trial, and on August 26th, the jury was out 1 hour and 15 minutes and came back. In a juvenile case, you don't say guilty or innocent, guilty or not guilty, it's true or not true. It's different terminology, results the same. The jury said both those first-degree felony counts were true. The part that really bothered us then, the defense attorney decided to go to the judge for punishment, and we put on a vigorous hearing at punishment given the nature of this. Cases, I don't want to get into the gory details, but I mean these are cases where we're talking about digital penetration, stuff like this. This isn't somebody touching somebody. They're much more egregious than that. And we respect the judge's opinion. We strongly disagree with it, but the judge makes the call. He was sentenced to about 3 years probation. And he will go through sex offender treatment counseling, but we wanted something much more severe than that. If you're going to give him probation, he was eligible for up to 10 years probation. The judge can get him 10 years and release him from probation early. If he decides to become a model student and comes back and petitions the court could shorten that. And that's the reason we were arguing for a much stiffer sentence. But anyway, that was 2 weeks ago, I guess. Another one we just did, you notice the ages again, same kind of thing. The perpetrator was a 16-year-old boy. The victim was his 4-year-old cousin. This was not quite as serious. This was 2 counts of indecency with a child. One by exposure, he was exposing himself to her, and the other by touching her, which is why it's a 2nd and a 3rd-degree felony. Again, that case was taken to a jury. They came back with true verdicts on both counts. Again, the lawyer went to the judge for punishment, and this kid now will turn 17 in January, so his sentence is just over a year of probation. And we really argued vigorously in this case. He's in a very, very dysfunctional home. His mother is, I mean, she has gotten right in the face of a young female prosecutor. She's almost attacked one of my male prosecutors. She vehemently denies he did anything. But the big issue here, and these are why some of these cases are difficult, the mother of the perpetrator and the mother of the victim are sisters. And so it's just absolute total denial. One sister is going to cover for the other sister. We were arguing he ought to be removed from the home. Our position is sex offender treatment is never going to work when you're in total denial of everything. And he's only got just over a year, to do this. And one of the first things you do is you start taking a polygraph test to go through that program. And he has got to ever work through that program, he's got to admit what he did in this offense and any other sexual offenses he's been involved in. We wanted him removed from the home. There's facilities like Pegasus, I don't know, a couple 100 miles or so away from here, where he probably could successfully get rehabilitated and so forth. But again, we respect the judge's opinion, but it was a 1 year and 3 or 4 months probation. I won't talk about this anymore, really. This is the burning death case. Most of you probably know about now, little boy that was torched, poured gasoline on him. Pre-trial comes up in that. Judge Hamilton, who y'all heard from not long ago, she was the juvenile judge back then when she certified the perpetrator in this case to stand trial. That was a 4-day trial to get him certified. There's what we say is the perpetrator on it. He's now 28 years old. This is an extremely complex case, a lot of legal issues involved in it. He has 2 of the best criminal defense lawyers around that we're all paying for, but I'm thankful for that because so many times you get an ineffective assistance of counsel claim down the road. With his 2 attorneys, I don't think that'll ever fly. I think the judge knows these two guys, very, very fine lawyers. And so the pretrial in that, I'm sure they're going to be asking for a change of venue that first week in October. They want it moved out of Montgomery County. That's going to be up to Judge Hamilton. If I had to bet, I would bet she moves it out of Montgomery County because all the publicity. This case, we resurrected it after 15 years. And I don't really have an issue with that. I'd rather eliminate one other avenue of appeal, saying it was in a county where you couldn't get a fair trial. But the bottom line is, no matter where that trial is, Judge Hamilton will preside over it, and the DA's office will prosecute it, along with my office. They've asked us to stay on that because we really know this case quite well. So that will be coming up. It's set for trial presently for January 5th. And I'm going to break here in any kind of questions. There's our office number. We have, a month ago, we moved across the street. If any of you have been to our office, I know some of you have been to Commissioner's Court. We're now officed in the Sadler building where Commissioner's Court is. First time in 25, 30 years the county attorney's office is in one building and on the same floor at that. So feel free to stop by. We occupy about 2/3 of that floor there now. So with that, let me open it up. Any questions, comments? I'll do my best to answer them. And I know Bill had one earlier you had sent about.
I have, right now we're sitting in the middle of a jail crowding problem. The Joe Corley was sold and built not for GEO, not for ICE, not for the Marshal's office. It was built to give us additional capacity once the current jail was filled. And this current, at the time, its configuration was such that it was becoming more and more crowded. They came up with an idea, etc., to try and get other parties to pay for the new jail. which is where ICE and GEO came through the door. Again, this was all in the paper at the time. Part of the deal involved issuing tax-free municipal bonds, and the tax-free municipal bonds had a 30% requirement for habitation by county prisoners.
Yes, at the end of 5 years,
At a date.
it was advertised that in 5 years, at least 30% of the facility would be occupied by county inmates, not federal detainees.
That's correct, 30%, and in the articles at the time, it also said at a 30% occupancy, the amount of income that we would be receiving from GEO, ICE, etc., would be enough to pay for the jail. And that's out of the Courier. Now, when we came to crunch time, January of last year, roughly, and we didn't have 30% in there, I would like to know what in the contracts precluded us from superseding the agreements based upon the need of the county to fulfill the requirement of the bonds. Was there anything in there? And if it wasn't in there, would it have been the responsibility of the county attorney's office, obviously prior to you and BD and others coming on the scene, to make sure it's in there? And conversely, do your agreements that you do now, if we're doing something of, I don't know, similar nature, that the needs of the county always come first? So I want to know if it's in those agreements, if those agreements are public documents that can be reviewed, and does that take a FOIA request to get them released so that we can look and see if it's in there, and if not, why not? So it's basically about why wasn't the county protected so that they could put the 30% in, including, I mean, if you sign a lease and you make alterations, if you make alterations and you leave, it's the landlord has the right to force you to pay for reconfiguring back to the original configuration. And why that wasn't in there. I mean, you know, if GEO did anything. In other words, we're sitting here looking, the number they're throwing out is 200 million. It's going to be another $100 million in interest on top of that. We're looking at this when we had a $65 million jail, which would take care of all our needs for the next 20 years. Fully paid for, would have been fully paid for by our ICE inhabitants. And now we're sitting here and we're looking at this enormous bill coming at us. And I'm wondering what was wrong in that agreement that we couldn't kick people out of there so we were able to meet the requirement for the 5 years.
Okay, let me do my best on that. And let me just emphasize also that and I'm not trying to dodge anything, it's just the truth. My office has no say whatsoever in policy. No matter how much I wish, boy, I sure wish commissioners wouldn't do A or do B, or wish they would do it or something. We don't get to weigh in on that. We just handle the legal aspect of it and make sure everything is done above board and by the law. Now, the contracts that Bill is talking about, those were, in fact, BD, some of you may have heard BD Griffin before. This takes fine lawyer. He's a 30-year lawyer I brought on board with 2 board certifications in real estate. There's no finer real estate lawyer around. And so we handled all the paperwork involved. When the commissioners decided they wanted to sell Joe Corley last year, and I think that was consummated about May, I think, of last year.
Right around May. Yeah.
We said, we'll handle the paperwork in our office, where before they would contract it all out, and they were paying Houston attorneys about $850 an hour to handle those things. Compare and contrast with that BD, who's you just heard me describe, his pay amounts to about $45 an hour. And he knows as much as those guys do. So we saved the county somewhere around $100,000 by just having us handle it. I'm not saying we agreed whether you should sell it or not sell it, but that's not our job. But we pulled the contract out again today when I saw your question, Bill. There appears to be nothing in the face of that contract that, no exclusivity, nothing precluding putting county inmates in there. In fact, the contract wording is such that we, the county, will provide space in Joe Corley for the feds on a as available basis.
Okay.
So in other words, we had first call on it, and then eventually Joe Corley's 1,287 beds, I think, mostly male, some female in there, and they're all either ICE detainees or U.S. Marshals, as I showed earlier. So we're not seeing anything in that contract back from 2008 that would have precluded that. Now, the 30% figure, a lot of people think, well, the county is about to get in trouble with the IRS. That is not correct. To get the bonds to be tax exempt, the county had advertised by the end of 5 years, at least 30% of that facility will be county inmates. And the thinking was eventually it'd be 100% county inmates like you're talking about. So you would have roughly the 1,250 bed county jail, right next door the 1,287 bed Joe Corley jail. And based on some of the things lately, that would have taken care of the county at least through 2034, I think is what that study showed.
At least. Well, they're at 2,200 at 2034.
Yeah, and so this is even more than
It's
that.
even longer than that.
This is, yeah, way more than that. And there is nothing in the construction of Joe Corley, because I hear people report, well, Joe Corley wasn't built right, and so they couldn't put county inmates in there. It has nothing to do with the way it was constructed, but Joe Corley is operated under federal jail guidelines. Our jail is operated under Texas state jail standards, and the Texas standards are a lot more stringent than the federal standards, like how many people overseeing inmates, that you can have the ratio of that to inmates is a lot different. How many inmates you can have in a given area. So the inmate population could not be as great, and I don't know what the number is, it would have to be reduced somewhat. But one of the kickers is if you put one county inmate in Joe Corley, the whole facility has to then conform to Texas state jail standards.
Okay.
For whatever reason, and that question is probably better asked of maybe the sheriff or something, at the end of 5 years, which was coming up last August of last year, I think, Joe Corley had never housed even one county inmate. And it's, the population varies daily out there, but it's close to capacity. If any given day at Joe Corley, there's probably 1,000, 1,100, 1,150 inmates, but they come and go a lot out of Joe Corley being federal detainees. So where the kicker was going to come in on the bonds, since it didn't meet the 30% requirement, the issue was going to be the bond holders that the county had issued those bonds to bought those in good faith that, hey, these are tax exempt bonds, and they were about not to be. So,
would that have been retroactive?
well, in fact, once again, we tried to anticipate that many months ago now, and BD went through and did a pretty detailed study on it, that if from that day on, if you had to make these bondholders whole, since they would not be tax exempt, I don't remember the exact number off the top of my head, but it was going to cost the county about $3 million. If it was retroactive all the way back to the beginnings of Joe Corley, the cost of the county was going to be $5 and something million, which you're probably thinking, well, that's kind of peanuts compared to the 200 I'm hearing nowadays. So it wasn't as though the IRS was going to get all over the county. It's these bondholders were going to get the shaft, and so the county would just need to make them whole. But
And
I mean, it's real money.
against attorneys and all kinds of things.
Exactly. So that's the deal there. And and in terms of the contracts you're talking about, absolutely, those are public documents. Just so it can be done properly, if you just submit a FOIA, Freedom of Information request, that's handled by John McKinney in my office, and y'all can have those right away.
Okay, thank you.
You pour over just what it says. That's the way we try to do things. You're entitled to them, so why do we want to fight it and go to the Attorney General and have the Attorney General tell us you get it? We know you're supposed to get it, so we give it to you. So.
Yeah, so without putting you on the spot, so if somebody said at that point that, well, because of the way things were, there was nothing we could do, there was nothing in the contracts which prevented them from getting a 30% occupancy. Is that true to say?
From everything I know, that
Okay,
is,
that's
there's
fine.
nothing that precluded them from having 30% in there.
Okay.
And just a couple of comments, things that impact the jail population in our county jail, which it's, I don't remember the exact number, it's around 1,250 inmates, and it's just bumping up. In fact, sometimes it's over capacity, and the state's already, on the county a little bit here, because you've got to handle everything by the book there. A number of things impact how long somebody's in our jail. One, a lot of it's up to the sheriff. And to my understanding now, every inmate in our county jail, this is not a prison, these are people in our jail. So they're either serving time for a misdemeanor, which would be a county jail time, or they're in jail awaiting trial on a misdemeanor or felony, or maybe they've been convicted of a felony and waiting on TDC to come get them, calling pulling chain and get them and transformed to whatever TDC unit. So the sheriff, and this has been going on for years, it's nothing new, everybody in our jail that I'm aware of is getting essentially 3-for-1 credit. Now, if you go spit in the face of a deputy or something, that's probably would change that. But they get, in other words, if you're sentenced to 60 days in Montgomery County Jail, you're going to do 20 days. And it's widely known, of course the DA knows it, so that's factored into plea bargains. So that affects, if the sheriff wanted to, and I'm certainly not advocating this, if the sheriff wanted to decide, I'm going to give you 4 days credit. You could certainly get people out of the jail faster, but is that a good solution? People have been sentenced to some time. Some people have problems with a 3-for-1. They were sentenced to 60 days. Why don't they do 60 days? So that's one aspect of it, is how much credit they give there. Another one is we're at the mercy of the state. So let's say somebody is convicted. This would be a felony case, and they're going to go do whatever time in TDC. TDC has, Judge, if I'm not mistaken, I think TDC has 40 days, I believe it is, to come pick up inmates out of Montgomery County Jail. If they don't, after that time, the state has to start paying the county. Before I believe it's 40, not 45, I think it's 40 days. Before the 40 days, guess who pays to house these inmates who need to be in TDC? The county is paying the bill. So if you're the state, when are you going to tend to come get these inmates? Right near the expiration of the 40 days. And so you've got, that number varies a lot, how many at any given time are sitting there waiting to be transported to TDC. And then the other factor really is how quickly courts can dispose of cases. And there are thousands and thousands of cases. Now fortunately, I don't know the latest percentage, but a small number of cases actually go to trial. Most of them result in plea bargains. And if they didn't, you couldn't build enough courts to satisfy the need. So those are kind of some of the factors that go into just how crowded our county jail is. And population grows like crazy, and it's a multiplying effect. So if you have jails, you're going to need more courts, you're going to need more people in the DA's office to prosecute them, and it just kind of goes on and on. So yeah, I think Walter was first. Yeah, Walter?
Boy, that exchange with O'Sullivan is above my pay grade on that thing. I'm telling you. Jeez. Hey, but I want to ask you, oh, by the way, that 3-for-1, that really is deceptive, because they put it, I know it's good for everybody. It helps facilitate the plea bargains. It makes the public look. You give 120 days, and the public is pacified when the guy's going to be let out earlier, and then the credits and all that. But anyway, I want to ask you, who is that Judge Stewart you had up there? Who is that?
And personally, I don't have any issue with Judge Stewart. Judge Stewart is the judge of County Court at Law number 5, so he handles misdemeanor cases. But we don't have a dedicated juvenile court in Montgomery County. The juvenile court historically has rotated every 2 years.
Okay, well, I don't have an issue with that judge yet. But look, because I don't really know. But here's you've talked about these certifications that Judge Stewart didn't grant. Now,
no, I don't think I've talked about any that he didn't grant.
Well,
the certifications I'm talking about, Judge Hamilton, who was the previous
Judge Hamilton,
she granted.
Yeah, okay.
Correct.
All right, she did not grant the certification. No, she granted the certification.
Correct, like in the Sligton horse case, she granted certification.
The lenient sentences, according to you. Who's the judge that did that?
These 2 cases I talked about now, because Judge Stewart has been the juvenile judge since January 1st. And it's his call. That's what judges get paid to do.
Well, I know it's his call, but it's our call to complain about it. But here's the problem. Here's the problem. We're only getting your view, and I think I know a little bit about these things now that occur. There's a district attorney named DeProm over there, you all know him. He's a big high-powered DWI guy and all that.
Warren DeProm, you're talking about, he used to be one of the assistant district attorneys.
Yeah, now he's moving to Fort Bend.
He's already, no, Warren has moved, he started his new job in Waller County.
Waller County.
Yesterday as the first assistant.
Well, here's the problem. When DeProm ran for judge over there in Fort Bend, I saw an ad of his. He ran against a judge over there, a juvenile judge, and he made mention that judge had refused to certify a juvenile. That was part of his political campaign. Yeah, you just rouse these people up, you know, and until you understand what's going on. Thank God the people over there in Fort Bend had the wisdom to reject the prom. Anyway, I don't like the prom too much. No, I didn't. But anyway, hey.
Did you have a question though?
Well,
I think you just surpassed
I had
Bill.
about a tenth the question that no Sullivan had. Okay, and you're not.
But I was more clear.
Yeah, I bet. I guess you're not going to answer anything about the letters, and especially about, I'm glad I don't owe you anything. You know, I'm really still upset about you filing a complaint against Ed Chance, because aren't you duty bound and ethically bound to represent your office, to represent the county commissioners, not to file suits against them?
Well, for one, we have not filed suit against any current or former county
You
commissioner.
threatened.
We just sent a letter demanding repayment of some monies. No lawsuit has ever been filed. And yeah, we're completely in the right. Sometimes, depends on what our role is on any given case. But yeah, there's no lawsuit filed against any of those guys.
buddy
Yeah, Jim?
Dahl is
Hey,
gonna
when are
agree
these, bringing that up, when are these guys gonna pay that up? You know, like Chance, he owes how much?
Well, he
Well-
doesn't
Doesn't
know
know
anything.
anything yet.
No, he probably owes everything.
Yeah, there's, again, the question is better placed with the commissioners. They call the shots. We have no authority to do anything beyond what they give us.
They'll probably let him off the hook.
And so, really, I would just ask that you bounce that off a commissioner. Julie, probably need me to get off stage here.
What's the deal with the new jail?
The deal with the new jail in,
What do we know about the new jail?
I don't know much. The commissioners hired a company called Broadus something, I don't remember what it's called, to do a study to figure out what are our jail needs for 20, I think they went out 20 years in the future.
Did they get paid for that?
Yes, and I don't know the answer to the question, you didn't ask it, but I don't know how much they got paid, but I am curious.
Oh, yeah.
Because to put it in perspective a little bit, you've heard all this talk about the Joe Corley Center. Joe Corley was completed in 2008. The county paid about $43 million for Joe Corley. And for whatever reason, at some point, commissioners decided to consider putting the facility up for sale. And all they did is what you call go out, request for proposals. No numbers are included. We have this facility, here's what it is, here's how big it is. Send us your proposal if you're interested in buying it. And that's how these things get started. It's not like listing your home or something. And there's a select number of people that want to buy a jail. And so Geo, who is a big time player, very reputable player in the jail and prison industry, they headquartered out of Florida. They submitted a proposal, and they did put numbers in it. Their proposal was roughly $100 million. They wanted to buy Joe Corley Detention Center, that the proposals went out about, but they also wanted to buy the facility sitting next to it, Montgomery County Mental Health Treatment Facility, which is a totally different kind of facility. They wanted to bundle the two together, and the total bid was right at $100 million. Well, that had to be rejected because, keep it to the letter of the law, the proposal was just about the one facility. So the proposals went out again, I think 8 different companies. You do a study to figure out, well, who's interested in buying a jail, other than Walter, but.
Put some of these lawyers in there, judges.
And so So Geo came back, and keep in mind, the county paid $43 million for Joe Corley. Geo came back and offered $65 million for Joe Corley. Eventually, last summer, the county decided to sell the facility for $65 million, and the county did net $22 million because we were trying to deal within the county. They didn't know what to do with this $22 million deal. They had never done it. So the county did net and cleared $22 million after the bonds and everything was paid off.
Wait.
Mhm.
What they also did, in other words, at the point they were offered the $65 million, the jail was appraised at 38.
Yeah, I believe that.
Right
that's
around
correct.
that number, okay? So then when the deal was done, it not only included the purchase of the Joe Corley, but it also included non-obstruction for the building of another prison next door on the land that they had purchased that nobody knew about, that they had made the purchase.
Well, I don't know about the nobody knew about part, but yeah, that was the clause, as I mentioned
Well,
earlier, the county
Key
would not.
people might have
hinder.
known about it.
Yeah, the general public probably didn't know that Geo owned that other land. But you know, the agreement included the county would, I don't remember the exact words, would cooperate, not hinder, because the key to those things is getting the contracts from the feds. And the feds want to deal with another government entity, and the county would help, you know, facilitate that. I don't know who was for Jim or.
He hadn't had a chance.
Does that continue, that continues?
I'm sorry, what?
That continues in the Joe Corley and whatever this new facility is, if the government takes over, and it would still continue at this, I don't know what you're saying, it's $5 million a year or whatever it is?
500,000 a year, the county
500,
gets.
so the county will, for the Joe Corley facility, the county will continue to receive approximately $500,000 a year, even though we don't own the facility, because the feds want the agreement with us.
Right, and it's not the feds paying us the 500,000. That was part of the agreement with Geo, that Fed contract is so important, so they're giving the county 41,000 something every month, just to make sure that, you know, we manage that contract and handle minuscule amount of paperwork.
And what,
Another part of that too.
And what happens with immigration reform by executive order to all these ICE prisoners?
You better ask the guy in the White House about that. I don't.
That's a rhetorical question.
Yeah, I understand. But let me do mention one thing though. It's in there about Joe Corley. I mean about Geo building another detention facility. If they do that, and it's for feds and so forth, the county also gets $500,000 a year in terms of that contract. So, you know, potentially if they build it, it could be
In
a
200 years, we'll pay off the new jail.
Yeah. Do we take one more? We need to move. Yes, sir. I think you have one. Yes,
Okay,
sir.
I don't know you, I'm not familiar with you, but perhaps you can answer this question.
I will try.
You showed something on there about, it looked like 3 different cases of, well, like Middleton, the guy poured gas on, set him on fire, and
Right.
those other 2 were a 16-year-old boy doing whatever to a 4-year-old girl,
Correct.
and he gets probation?
That's correct.
Was that this Judge Stewart? How can I hunt him down?
Well, no.
No.
Understand, there's limits in the law.
Judge Stewart had nothing to do with the Robbie Middleton case, the burning death case. And Judge Hamilton, who oversees that, by the way, she will be the one that tries it. It's just these other 2 cases we just had recently. We just have a distinct difference of opinion given the egregious nature of a 16-year-old or a 14-year-old and a 4-year-old child. We just wanted something much stiffer. They're very limited in the juvenile realm what they can do unless you certify them to stand trial as an adult. And we're very selective about that because judges aren't
Oh, yeah, well,
normally going to grant
you're
it.
probably a lot closer to that than I am, but how can a red-blooded American judge stand there, sit there, whatever, and assign 1 year probation for what this guy did? I don't know what he did, but it had to be bad.
Well, that was what our opinion was. We just, I think we had 8 or 10 hours of testimony.
And there's nothing you guys can do about it.
No, even in cases like that, the judge appointed an independent, I forget if Kid is a psychiatrist or psychologist, I forget which Kid is, Dr. Kid Harrison, one of the most renowned experts in that field. He's not our expert, he's not the county attorney's expert, he's not the defense expert. The judge appoints that to evaluate this young man and come to court and make a, he prepares a report, makes a recommendation. Dr. Harrison's strong recommendation, he was on the stand for an hour or so the other day, was this kid would not be successful in sex offender treatment. And by the way, Montgomery County does have a very successful juvenile sex offender treatment program. But you've got to fully cooperate and, as I said earlier, admit to these kind of things and so forth. Kid Harrison's recommendation was particularly because of the extreme dysfunctional family that this young man comes from, and you've got the victim and the victim's mom and the perpetrator's mom or sisters. He thought this kid needs outpatient treatment. That'd be about a 2-year program in a facility like Pegasus or something. But, the judge saw it differently. Now, we'll be monitoring it. If he doesn't toe the line, do everything he's supposed to do on probation, we'll be back in court seeking to have, see if that, you don't have to worry about that. My prosecutors will string me up if we don't do that. They were not happy when they left the courtroom, because when you look, something is, in my opinion, something, in Dr. Harrison's opinion, when you've got a 14, 16-year-old doing things to little kids like that, this kid needs a lot of treatment. And the worst part of it, too, is that little girl needs a lot of treatment and counseling. The impact on this, almost immediately her family testified about the impact of it, her interaction with other male figures. It's totally different now. And I can't put myself in her shoes, but and another thing, too, is those little kids have to come to court, take the witness stand, and testify. And if I'm that little girl right here in the witness stand, the perpetrator is sitting just about where you are. And it takes a brave little person to come do that. And if they don't sit there and answer questions, and they get cross-examined by the defense attorney also, and the jurors all met with us afterwards, and they say, we believe everything that little girl said, because that's what hinges on. If that victim doesn't testify, the guy walks out. So
we'll just find out when Judge Stewart's up for reelection.
No, you have to understand, there's a difference in the law and what a judge can do. And you're only hearing one side of the story. I know Judge Stewart personally, and that is the most fair man you could ever have to hope for on the bench. He disagreed with JD's version of the law. He read the law, he looks at everything there, and he disagreed with him. There's a good reason why he ruled the way he did.
Yeah. And I'm sure that the only thing I would take exception to for Judge Case, if you don't know him, it wasn't, in this case, the interpretation of the law, because he could have easily sentenced him to 10 years probation. His interpretation of the law was differently in terms of removing him from the home. You're exactly correct on that. He didn't think he could remove him from the home, place him in a treatment facility. Okay, I'll grant him that, different legal opinion there. But he could have sentenced him for up to 10 years probation. And like I said, if the kid decides to straighten up, fly right, goes through the sex offender treatment program, becomes a model citizen, even though it's a 10-year probation, the judge could cut him loose after 2 years, 3 years, 4 years, whatever. But instead we got the very short, and that's where our issue was in the case. We're not complaining about his interpretation of the law differently in terms of being able to remove him from the home. So.
Can you tell me where we're at on the Officer Masden case, or can you comment on that?
On which case?
Officer Masden over in Magnolia?
Yeah, tell me.
It was the property rights issue. The guy came out with a gun after, the property owner came out with a gun after a vehicle crash on a wet road.
Yeah.
He locked him up in the car and the
unfortunately, and I hadn't asked to get it updated in a little while on that, so I'll be happy to let you know if you give me your card or something there.
Okay.
Off the top of my head, I don't know what the latest is on it. We got so many cases going on at any given time. But I'll be happy to, whatever we can share, I'll be happy to share it with you. I just don't know off the top of my head. But one more question. I got to get out of here. You guys want to get home.
No, I just want to say, how can you keep up with all of these?
Well,
it's amazing how you...
One, I've been blessed with a lot of energy and enthusiasm, and like in a lot of these cases, I might be sitting there in court, but I don't go sit at council table. My guys and ladies, they know what to do. They don't need me, but I like to be there to show them, because they never saw that before. That guy, the county attorney, is in the courtroom sitting with us and showing the support and so forth. If there's a question they want to ask me, they will do that. But they know what they're doing. But I just truly love this and the variety of what we do. One minute we're involved in paperwork to sell the $65 million jail. The next minute we're handling open records. The next minute on a car crash, and then we got these juvenile cases and baby flying out of a car window. So you've got to have the right mix, the right kind of people. And I've got, I think, a great mix of people that used to be in the office. I still have some of those people there. And I tell you one thing, it has made a tremendous difference in my opinion. Because I know the campaign, people that weren't supporting me said, well, he's never worked in the government. He doesn't know how to run the county attorney's office. I think that's one of the greatest strengths I've been in the office. And I've only got one person I brought in that's ever worked for the government. And you can't believe, like day in and day out, well, why do you do this? That's the way we've always done it. And when you see, you just come in with a whole different framework, a whole different mindset, and look at things that we've been able to streamline, and I think that's why we got the department of the year. That's all these department heads and everybody else that were advising supported that. So, anyway, okay, thank you guys. I appreciate it very much.
Thank you. As always, you're always here. You're always willing to share whatever you can and answer our questions, and we appreciate that very much.